Anything but mentioning, ma'am, at 2 o'clock. Yes, yes, Mr. Ramachandran.
May it please your lordships. My lords, the last session closed
Yes.
with Dr. Singhvi reading out some stirring words. It is appropriate, my lords, in the context of the slightly different perspective which I am presenting, to read out some more stirring words of this honorable court. Way back, my lords, in 1956, the iconic Justice Vivian Bose said, the Constitution also exists for the common man, for the poor and the humble, for those who have businesses at stake, for the butcher, the baker, and the candlestick maker.
He said, yes.
Then, my lords, in 1982, one Randhir Singh, a constable driver of the Delhi police, came before this honorable court asking for equal pay for equal work. And the first paragraph of another master, my lords, Justice Chinnappa Reddy, is stirring again. Because the judge says, true, he is the merest microbe in the mighty organism of the state, a little clog in a giant wheel. But the glory of our constitution is that it enables him to directly approach the highest court in the land for redress. It is a matter of no little pride and satisfaction to us that he has done so.
That he has done.
That he has done so. Then further, minutes I won't read. And it is in this context that it's important for me to state who the two petitioners I am representing are. Petitioner number one Kajal, is a Dalit woman from the town of Muktsar in Punjab. And her partner, petitioner number 2, Bhavna, is an OBC from Bahadurgarh, Haryana. Bhavna works as an accountant in a company in Chandigarh, and Kajal works as an assistant in a bakery in Chandigarh. She is the baker whom Justice Vivian Bose had in mind. And therefore, the very presence of these two petitioners and similar petitioners like Ms. Grover's client should put paid bullets to the glib assumption made in the government's affidavit that they are urban elite. That statement, with respect, Millets, was careless, unnecessary, and with respect, insensitive, Millets. And the reason for stressing the background of these petitioners and the nameless others who might be like them is to say that the institution of marriage is not just the gateway to various socio-economic rights, which my two predecessors have sufficiently focused on, but it is a societal protection from their own natal parental families. Such couples don't have enlightened parents. They don't have understanding families. The two petitioners before your lordships had to move the Delhi High Court for protection orders. Those orders are on record as part of my written submissions. And therefore, the point which I wish to emphasize is that the recognition of their marriage is an important protection to them. A societal recognition which protects them from society and from their own parental families in given cases. Now, having offered that overarching perspective, minutes, I am dealing with the matter under just 4 or 5 heads, which I'll quickly enumerate. One is I am offering another interpretation of section 4, which should fortify the interpretation which Dr. Singhvi gave for reasons which were not articulated in the manner in which
So first is
I wish to.
interpretation of section 4.
Lordship, please. Secondly, my lords, there is another aspect of both 1421 and also 25 freedom of conscience, which I will briefly touch upon. Third, my lords, is the aspect of notice, where the submissions made will be fortified with reference to the historical background. A little background is necessary, which we have set out, and I'll just briefly draw attention to that as to how and in what context these notice provisions came into being and how they are so utterly out of place in today's context. And lastly, a point which I mentioned briefly in an intervention yesterday, for people like us, any judgment of this honorable court, assuming we succeed, will be incomplete unless, as we have prayed, a protocol is put into place on the lines of the Shakti Vahini protocol, which your lordships laid down in the case of heterosexual couples seeking protection from what was called Khap Panchayats. A similar protocol, milords, is imperative. So may I, milords, quickly
Yes.
proceed on these lines first. Kindly turn to section 4. Yes, milords. Notwithstanding anything contained in any other law for the time being in force relating to the solemnization of marriages, a marriage between any two persons, so here persons, may be solemnized under this act if at the time of the marriage the following conditions are fulfilled, namely, neither party has a spouse living, neither party is incapable of giving valid consent, etc. And then, for the first time, come the mention of male and female. The male has completed the age of 21 and the female the age of 18 years.
Right.
Kindly note that the words male and female are not suffixed with the word partner or with the word party. Therefore, without in any manner intending to contend that the kind of union which we are asking for recognition for was contemplated at this act, my endeavor is to point out that the language of this act enacted in 54 itself, without your lordships having to do violence to language, is capable of accommodating situations like ours, because if it is a male union, or a male transgender male union, or two transgender male unions.
Come again. If it's a male union,
or a male transgender or trans man, let's say, male trans man union, or a trans man union, then 21 will then refer to them. Correspondingly, 18 will be attracted to a female, a female trans woman, a trans woman, and that can also accommodate 1/4 category, which is transgender person. That could be read into 18.
Have you articulated it in your written submission?
Lordship, please.
You have?
We have that.
Can you
We have
take it?
minutes. Page 690 onwards are our written submissions.
Yes, we have it.
So 18 will apply to female. 18 will apply to female.
Female and female trans woman and trans woman.
So we can use, according to you, one can import the Transgenders Protection Act.
Lordship, please.
Let's see those definitions.
Lordship, please.
Trans man, trans woman.
Yeah. Trans man, trans woman.
You are talking of two categories.
Lordship.
Trans man and trans woman.
Lordship. This approach, if adopted by this honorable court, will not be doing any manner
But then
of-
there could be certain categories left out.
Lordship, please. Lordship, please, minutes. But a trans man could still broadly identify with male. That's a sacrifice, a descriptional sacrifice which person seeking the protection of this institution would also have to make.
Right.
There are people who may feel they don't want to be compelled to identify by a particular gender. But if you seek the protection of this institution under this act, that's an accommodation. They will have to come those few steps forward. What the lack of logic which will still remain will be the 18 and 21, which we will just have 2 minutes with respect swallow, for the reason that the very age differential which the law
Is
prescribes.
subject to a challenge.
Lordship, please. It is subject to a challenge. It is rooted, milords, in the traditional perception, a patriarchal perception, where the male is the bread earner, the provider, must be old enough to earn, and the female is the child bearer, and she is fertile at 18. That is the archaic logic behind this age differential that can't be.
There's a bill which is being considered for equalizing the age.
Lordship, please. Lordship, please. Lords. So for the moment, we'll learn to live with this lack of logic here, milords, as long as it can be accommodated, milords, within these two categories. Having made that submission, milords, may I proceed to the next, milords? Now, milords, when it comes to Article 14, just one additional point in the context of what Justice Kohli had put to Dr. Singhvi yesterday. Justice Kohli's question was, is it a restriction or a lack of recognition? To which the respectful answer is, it is a lack of recognition, and that lack of recognition leads to the denial of the equal protection of laws within meaning of Article 14, and NALSA para 62, which is set out in my written submission, specifically deals with that. Therefore, the lack of protection is sufficient to create a situation of unconstitutionality
Which can be avoided by reading
by
this act.
an appropriate reading of this act. Then, milords, facets of 21, which further need to be highlighted, are two. My right to health would include my right to have appropriate medical decisions taken for me by the person whom I love, and so often in such situations there's an alienation. Again, we are not talking about urban families. There's an alienation from the parental family, and so in such a case, in the event of sickness, the individual is left without a person who can take responsible medical decisions, who can sign the hospital consent form, the ICU form, whatever.
No caregiver.
Lordship, please. No care.
No legal caregiver.
No legal caregiver.
That's a 21 argument.
Lordship, please. And there's one more facet of the 21
Yes.
argument. And it is this. If I am gay or lesbian or any of the other categories, then my health and happiness depend on a fulfilling union with a person of my choice.
Yes, this has been covered.
This has been covered.
Lordship, please.
The right
And
to,
it's an aspect of mental health. It's an aspect of mental health if I am
of
prevented from.
The point
That's
of
all right.
happiness includes wellness.
Lordship, please. Lordship, please.
The fullness of one's life.
Lordship, please.
In fact, there's a whole segment in my judgment in Navtej which deals with the right to health, the right to mental health.
Lordship, please. Lordship, please. And my lords, 25. I will only state it. And 21 also would include the right to found a family, my lords. The right to found a family, the Yogyakarta principles, we have set them out here.
Yes.
Those would also be part of my right under 21. The right to marry. If I have a right to marry, then I have a right to found a family.
Yes.
And 25, freedom of conscience. I have a right to my own moral compass. Having made these submissions, bullets, I will come to the main area where I need to take my lords in a little detail within the time allotted.
Notice. Aspect of notice.
Aspect of notice, my lords.
Fair enough.
Absolutely. Now, my lords, the legislative history of the Special Marriage Act, my lords, is set out from page 695 onwards of my written submission, page 698 of the PDF. Page
Why don't you
698.
tell us orally so that we'll be going through your submission?
Lordship,
Have
please.
enough-
I'm not going to read. I'm not
Give
going
us
to
a
read.
broad
Yes,
perspective.
the broad perspective is originally there was no codified law of marriage in India. It was all customary and religious. Then, during the time of the British, a need was felt for a law of marriage for the British in India. And so that's how legislation came. So that those provisions contemplated marriage only among Christians.
Yes.
Then comes Keshav Chandra Sen and the Brahmo Samaj. And their demand for a secular law of marriage for the Brahmos to be able to marry in, though they did not mind calling themselves Hindus. But the law at that stage, and the chronology is there, required parties to renounce their respective religions. Not being a Hindu, that was a prerequisite. Only to save time that I'm not taking my lords
Yes.
through the language, it's all there, words. That changes in 1923. After which you are no longer required to renounce your religion. But there is a severance of the joint Hindu family status. Which continues, that severance,
The Special Marriage Act.
in the Special Marriage Act in 54, and is ultimately undone
In 1976.
in 1976. So that is as far as the law of marriage is concerned. And now, let's we come to the history of notice in the context of these very laws. And what your lordships would find surprising is that they originate in a 1753 Act of the British Parliament, whose name speaks for itself. It is an act for the better preventing of clandestine marriages,
Huh.
1753. So the Lordship, please. So therefore, a provision which originates in a preventive statute now continues through the Special Marriage Act, which self-confessedly is an enabling statute. But there these provisions are imported.
Part of your written submissions is covered.
Lordship, please, Lords. Kindly, Lords, PDF 725. Then we'll come to. And Lords, at same page 726, Lords, para 98, there is a table which has been set out giving the history of the notice provisions. And this 30 days notice is the longest ever. If you go to 1753 Act, it was 3 Sundays.
3 Sundays.
3 Sundays. Because Lords, weddings were in church. Maybe that was the significance of Sundays, Lords.
Yeah.
So
Now,
the effect is to defer your right to get married at the time when you desire to.
I'm grateful, Lords.
And it can't be regarded as procedural because the impact is on your substantive right to get married at the time that you choose.
I'm obliged, my Lord the Chief Justice has summed up my argument on this. My submission is that this notice requirement amounts to the requirement of giving a notice for exercise of a fundamental right. If my fundamental right to marry is read into 21, then I can't be asked to give notice of the exercise of my fundamental rights at a future date in the context of a notice regime which is designed by the sheer length. As my Lord the Chief Justice pertinently observed, Millards, a procedural notice is different. If you say 2 or 3 days notice so that the registrar who's in some other town at least is performing other duties, keeps this day aside for registration of marriages. So that's a different kind of a notice from a 30-day notice which is designed to enable parental families and other busybodies to create roadblocks. And my Lord Justice Ravindra Bhatt, sitting as a single judge in the Delhi High Court, had to deal with such a situation in a case whose reference I have given, where the enthusiastic marriage registrar not only sent the notice to the parent jurisdiction, because if you move out, you elope, let us say, just to use a loose word, you go and settle in another district, 30 days domicile there. If you register in the new domicile district, notice has to go to your old district, your permanent district. But the enthusiastic registrars also sent it to their addresses, to their families. So the judgment of the Delhi High Court, to which I am making references, the obligation is only to paste a notice, put it up on your notice board, not to inform families. And that
Right.
judgment refers
Right.
to the deleterious effect otherwise
On the
of this having on the freedom of choice of parties.
And if the purpose is to ensure that people do not enter into a marriage which will suffer from being void, then this is not the least. This is not the least restrictive means which the proportionality test requires us to adopt
Lordship, please.
to ensure that purpose.
Lordship, please. Lordship, please. And especially when there is adequate provision in every law, if in the Hindu Marriage Act, a marriage within prohibited degrees is entered into, the Act provides. This Act provides for penalties and punishment for making a false declaration. So it is not that people in prohibited degrees of relationship will go scot-free. But you can't postpone. And in situations like this, which we are facing, the postponement creates the possibility, the real possibility of families intervening and putting an end to the relationship. And therefore, this notice period.
Also, Mr. Ramachandran, there is a very real likelihood and not just a remote possibility that this will disproportionately affect situations in which one of the spouses either belongs to a marginalized community or a minority.
Lordship, please.
So it has a disproportionate impact on those who are the most vulnerable segments of our society.
Lordship, please, words. Lordship, please, words. Lordship, please, words. And this requirement of 30 days domicile, one is the notice per se, but the 30 days domicile before you give your notice. So a runaway couple has to choose a new abode, and before getting married, kindly see the problems they run into. They are not married. Which landlord will give premises on rent for those 30 days or 60 days or for however long they want to stay? Where are they going to stay in that new place of domicile?
Mr. Ramachandran, this would be equally true for heterosexual couples who propose to have.
Lordship, please, it should be struck down for all, Millards.
Applies.
This was,
Lordship, please, Millards, it should be struck down for all. It is a totally retrograde provision today.
As long as you prove that you're adults.
Lordship, please, Millards. It is both retrograde and obnoxious
now you
to require this notice.
So on your Aadhaar card, no? Identity will carry your date
For
of birth.
age,
And if I am correct in this submission, then what are the main provisions which need to go and what are the consequential provisions which need to go? I'm just reading out those words.
Main provision.
5 to 8 will be the main provisions. Whose striking down we have specifically challenged.
5 to 8.
But the consequential 7 to 8 minutes. Yes. The consequential provisions or the provisions in aid which need to go would be 9, that is powers of inquiry given to the marriage officer. 10, procedure on receipt of objection by marriage officer abroad. Then minutes 14, new notice when marriage not solemnized within 3 months. So for some reason you can't solemnize, and perhaps it's not solemnized because parents have kidnapped. So when they finally get together again, another
Again, go back
notice,
to the same.
then another notice. And minutes, finally, the provision which needs to go consequentially would be 46.
46 क्या है?
You said 5 to 10, right?
5 to 8, then minutes 9,
10, 5 to 10.
and then
Penalty for
10.
wrongful act.
Yes,
On
minutes
the
5
marriage
to 10
officer.
minutes.
On a marriage officer.
Yes, minutes. Lordship, please. I'm grateful.
40?
Then 14 also I had mentioned minutes, but just note to 14, and then 46.
The penalty.
Yes, minutes. Penalty for wrongful action of the marriage officer. Because if this notice provision goes, one of the things he's penalized for is.
All right. So we're
not
done with
publishing the
item
notice.
3. Now, what is point number 4?
Now, minutes. Point number 4 comes straight to my last point, which is the need for the protocol. So families, couples on the run from their parental families need protection of the state through the aegis of this court. Because on the same S. Rangarajan versus Jagjeevan Ram principle, which is taken by your lordships through various judgments, if the state has the duty
Protect.
to ensure protection of fundamental rights, then such a protocol is necessary. I respectfully commend to your lordships
Kaushal.
the Shakti Vahini protocol, where minutes in a parallel situation, only thing is the couples were heterosexuals. Those were community panchayats, khap panchayats. And detailed directions have been given in para 55 onwards of the judgment of Shakti Vahini. I did not read out.
Equally, we have to be careful that in the guise of the protocol, we do not empower these officers who come into possession of information
Lordship, please. To
then
leak.
use informal methods of suborning the couple. That's
Lordship, please.
also one thing, a danger which we have to avoid. But there has to be a protocol to protect.
Lordship, please.
Protection is sought.
Lordship, please.